Thank you, thank you. So concurrent adjustment of status, as I mentioned before, is the single most immediate concern when we see the visa bulletin. So for many of our clients, the ability to file the I-485 with the employment authorization and the travel document applications is really critical. In one of my recent blogs called Why EB-5 is Better, it's one of the points I emphasize, that when the Reform and Integrity Act added concurrent adjustment of status for EB-5, it really created a boon for the EB-5 industry. So this, for some people, at some point, when there is a quota cutoff date, the ability to do concurrent adjustment of status will go away. However, the good news is that if you have filed concurrent adjustment of status, even if there's a long quota backlog, even if it's years and years of a backlog, you will still be able to keep and extend your employment authorization. You will still be able to keep and extend your travel document. If you were an Indian EB-2 or EB-3, was dependent on continuing to work with your employer, you'll still be in a position where you're not dependent on an employer, and you can continue to extend the AD and AP. Now, there's two different sides to this coin. On the one hand, if you're in the US and you were thinking of EB-5, again, this may lead you to decide to do it sooner rather than later. And I think it was Sam mentioned, you will get some notice of the quota backlog, usually about 20 days or so in advance of the cutoff date being implemented. You receive an advance copy, or we receive an advance copy of the visa bulletin that tells us on the 1st of the next month there will be a quota backlog. And so we'll usually have the better part of 3 weeks to act quickly to file concurrent adjustment for those who want it. However, again, as I've said before, this does not mean that it's a wonderful idea if you're outside of the US now to come in on a B1, B2 visa and immediately file a concurrent EB-5 and I-485. Because without going into a lot of detail, because we've done it on other webinars, but there's something called preconceived intent. And in many cases, it's a good idea to wait some number of months after entry before filing for concurrent adjustment of status. The second thing to talk about is the Child Status Protection Act and the issue with children who are nearing the age of 21. So what you need to understand is that the Child Status Protection Act protects against long processing times by the Immigration Service. So if the 526E takes 18 months for USCIS to adjudicate, that means that the child's age is frozen during those 18 months. But if at the end of the 18 months, and there's now an approval, and the quota is not current, there's a backlog, then the child's age is unfrozen. It's no longer frozen. So when we have no quota backlogs, it's usually safe to be able to file the 526E before the child's 21 and protect the child's age. When there are quota backlogs, it becomes important to file, some period of time, preferably years, before the child turns 21. And at that point, when we have a child who's concerned about aging out, the slower the government processing time, the better it is. Because if my child's aging out, I would rather have the age frozen for 2 years rather than 1 year. And that means I'd rather have my 526E pending for 2 years rather than 1 year. So that changes the quota cutoff dates, change the equations on the advice we give to families with children that may be turning 21. Next thing I want to talk about is the impact of the cutoff dates on when somebody's going to receive conditional permanent residence. It may well be that relatively short quota backlogs of a year or two, for example, may have little to no impact on when somebody's going to get a green card. Right? The quote, your place in line, your priority date is established on the date the 526E petition is filed. So once you are filed, let's say it takes 2 years to adjudicate the 526E. And let's say the quota is backlogged by 2 years. Well, by the time you get the approval, your priority date from 2 years ago is current. So in some ways, and I do expect we'll talk about this, you'll see later on the slide, we'll talk about the impact of the Trump administration. But for reasons we'll discuss, it's certainly very possible that we're going to see longer 526E processing times. And that could actually minimize the impact of the quota backlog because it may be by the time the 526E is adjudicated that the quota is available. What we end up seeing in forthcoming visa bulletins will certainly have, as Ahmed was talking about, an impact on project selection. So as we stand or sit here today, many of us are guessing that the high unemployment cutoff dates will happen sooner and maybe be longer than the rural cutoff dates. I can't tell you I'm 100% certain of that, certainly possible. However we and our working with our immigration lawyers view this, we certainly need to take into account when we're choosing a project, how important it is to us regarding what the quota backlog will be. And there's obviously a lot of factors that go into project selection. But if our single most important issue is which is likely to have a longer quota delay, it may be that high unemployment will be that, and that may or may not influence our selection of a project. The sustainment period is complex, and again, we did another webinar with the folks at EB-5 on this subject. So the concept here is, well, how long does an investor need to keep their investment pending in order to be able to complete the permanent residence process? And right now, the law is extremely unclear. The Immigration Service regulation says that you have to sustain your investment for 2 years beyond the date that you get your conditional permanent residence. The Immigration Service pronouncements about a year or so ago, based on their interpretation of the RIA, is that you don't have to sustain it that long. You only have to sustain it for a total of 2 years from the time you make your investment. How that will end up being resolved will be determined by a federal court, and is presently pending in federal court litigation. The bottom line is that if you're conservative and you're going to stick by the language of the regulation that says you have to sustain your investment for 2 years beyond the date of your conditional residence, quota backlogs will potentially significantly extend the sustainment period. Because if it takes you longer to get your conditional permanent residence, let's say it takes you a year or two longer than it otherwise would have, then that's going to extend your sustainment period by another year or two. Good news, if you want to call it good news, is that the longer the quota backlog, the more time the project has to meet the job creation criteria. Now, we get involved in probably hundreds of different projects. And we see projects where there's going to be more than enough jobs and more quickly than needed, and there's really no issues. We also see projects where job creation is delayed, the project's delayed for any of a number of different reasons. And actually having more time for job creation before the investors need to file the I-829 condition removal petitions is a good thing. And so for them, the longer quota backlog, longer retrogression periods mean that it will be a longer period of time before we have to file the I-829, and therefore a longer period of time for the project to meet the job creation criteria. Priority processing has always been viewed as a good thing, and only rural projects get priority processing. And my experience has been that the Immigration Service actually does process rural cases with some priority, more quickly than they do non-rural cases. That's always been a good thing, and the reason that some people choose to invest in rural projects. However, understand that a couple of things. Number one is priority processing is counterindicated, is not great if you have a child that may be aging out. Because as I said before, you want to have your petition pending as long as possible in order to freeze the child's age as long as possible. If the Immigration Service approves the petition in 2 months, and then there's a quota backlog, the age is unfrozen as of 2 months, and the child may age out. The other thing to keep in mind is that priority processing results in more rural cases being approved quicker. And that means that, if they're approved quicker and more of them, more numbers will be used. And that means that there will be more quickly quota backlogs coming up for, based on newly filed rural petitions. The last thing I want to mention on this slide is, there's nothing much in the world, and certainly nothing much in immigration or in EB-5, where we should not take account of the new administration. So we have some history with the Trump administration and 4 years. During the first 4 years of the first Trump administration, we were in a situation, it was pre-RIA, and we really had no regional center program for all intents and purposes. So we didn't see a lot of concern about processing times for 526Es. But what we did see, or those at that time was 526s, what we did see in all other aspects of immigration, including employment-based immigration, is that everything slowed down, and in many cases slowed down very significantly. And there was a very, very, very substantial decrease in the number of people getting green cards during the 4 years of the Trump administration. It was done in many ways. There's longer processing times of petitions, more RFEs and NOIDs, higher denial percentages, significant reduction of consular officers, which resulted in longer waits to get immigrant visa interviews. Most or all cases requiring interviews. Ultimately, all of these things resulted in decreases in the number of immigrant visas actually utilized. Now, that's obviously not good news. However, and many of you know this because certainly our office is inundated with people, EB-5 and every other category, who want to get things filed before January 20th. It's a very, very busy time for us. The only good news, if you want to call it that, is that all of that could result in fewer immigrant visas being issued starting in February of 2025. And if in fact fewer immigrant visas are issued, it could delay the onset of visa cutoff dates. So those are, without giving you projections and predictions of when and how much, those are 8 thoughts I wanted to share with you that I think are important as you judge your decision-making and your strategy with EB-5 quota backlogs lurking in the background.